I want to introduce our moderator, Uzi Renan. Uzi is a bankruptcy partner, a lawyer, a member of the California Lawyers Association Business Law Section, and a member of the California Lawyers Association Board of Representatives. Uzi is going to, as I said, serve as our moderator. And one of the reasons I asked Uzi to serve as our moderator is because I spoke to him about something else, and he had all these piles of paper around him and said that he was actually working on an application for a PPP protection. And so he's got some real world experience as an applicant. On that note, I will turn it over to you, Uzi, to kick our program off. Thank you. And thanks to everyone for participating.
And Ona, thank you for the introduction. I want to get started fairly quickly. So let me first say welcome to everyone who's on our program today on the Zoom chat. You are here for the PPP, the Payroll Protection Program, the PPP program. We'd like to focus on a number of different issues that would allow you to understand what it takes to qualify, what it takes to comply with requirements. And let me start by talking about, for those who don't really know much about the program, the PPP program was enacted pursuant to the CARES Act, which is a Coronavirus Aid, Relief, and Economic Security Act that was enacted by Congress about a month ago. The goal was to try to encourage small businesses to rehire any employees that they let go and to maintain the payrolls and maintain employees in employment as much as they could. It's a very limited program. It's only intended for about 8 weeks or so. The last opportunity to apply will be June 20, or is it 30 of this year? And so it's not a huge amount of time to June 30 to apply. The program, as you know, has been somewhat controversial in the way it's been enacted. It's been somewhat controversial because of the lack of sufficient guidelines, as well as clarity, the types of businesses it covers or doesn't cover. It's supposed to be a first come, first serve. However, some banks didn't necessarily treat it that way, or at least that's the accusation. And, there's been some concern that some banks perhaps preferred some clients over others. None of that is really the issue for today. We certainly acknowledge that these issues exist, and they will be debated for years to come. Rather, what we'd like to do is, again, focus on what it takes to qualify, and then ultimately what it'll take to comply with the requirements. And probably the most important thing you're concerned about is, if you get the loan, what do you need to do in order to get forgiveness of the loan? So it becomes more of a grant rather than a loan. So let me introduce the panel. I don't know how you're seeing everyone up on the screen, but we have Christopher Carajale, who's a partner at Hanson and Bridges. He's a San Francisco-based tax attorney with an LLM in tax, who advises individuals and businesses on tax matters, both domestic and international. We have Linda Geary, who's a CPA shareholder and vice president at Gilbert CPAs in Sacramento. She oversees the firm's tax and accounting services. We have Paul Notaris, who's a partner with B2B, he's a CFO, which is a CFO exit transition services company. He works with CFOs, business owners, and other stakeholders on strategic performance, financial and other planning issues. And as Ona mentioned, I'm a bankruptcy attorney at Danningale in Los Angeles. So why don't we start with just the basics. Chris, what is the PPP and what does one have to do to qualify?
Great. Well, thanks, Uzi. Yeah, so I think we're all going to talk together and provide, the goal of this webinar is to provide some anecdotal experiences, and we're sort of from different sectors, and ideally we can share the different things we're seeing. But and I assume many people have already done some research on PPP qualification, but I figured with Linda's help and Paul's input, we'll give a little background for the first few minutes so we're all on the same page, right? So, the PPP was initially, as Uzi said, passed as part of the CARES Act, and that provided for about $350 billion of these loans to go out to small businesses, right? As the Senate and then the House just, I understand today, passed H.R. 266, which added another $300 billion to the PPP program. So I believe that on Monday, the first tranche of $350 billion was exhausted, but now we have another $300 billion to be deployed to small business owners. As Uzi said, the key here is a little semantic, right? That these PPP, these are called loans, right? But in fact, if a taxpayer and an employer rather adheres to the various requirements, it's actually a governmental grant, right? That is, it's money provided to the employer to hire or maintain workers, and if the employer maintains these various criteria that we're going to talk about, that employer, that loan is forgiven, and the statute, the CARES Act section, I think it's 1106, says there's no forgiveness of indebtedness income, right? So it's called a loan, but it's not. It's a grant, provided the employer complies. So in terms of we'll run through some of the basic requirements, and then I'd like to hear maybe from Paul and Linda as we talk about these. You know, the requirements to receive the loan are pretty simple. There's only two prongs. The first is that the company has to have 500 or fewer employees whose principal place of residence is the United States. There's some special rules for franchises and other things, but I think the bottom line is that if you have fewer than 500 employees in the U.S., you can comply. And second, that the company was in operation on February 15th, 2020, and at that time either had employees for whom it was paying W-2 wages, or was a company with contractors, that is a sole proprietor or a self-employed individual. Right? So the first big issue, and the one that I think when the guidance first came out concerned a lot of practitioners, was what does 500 employees mean? And I think there's four important issues under this topic that I want to address. The first is the affiliation rules, right? Congress recognized that if we have companies that are, you know, owned by the same owner, and you go over the 500 threshold, right, you're not actually going to be dealing with small businesses. So the PPP grafts onto the SBA rules about what affiliation means. And I think generally you say, look, if a single person owns or controls more than a single corporation or other legal entity, you have to aggregate that person's ownership through other companies, right? And of course, the goal here is to not be in a situation where large companies with more than 500 employees get the grants. Paul, you said you had an experience on this affiliation issue, is that right?
Yeah, that is, not to get into a civics class, but that is actually from the beginning of the SBA, a fundamental definition within the SBA, which is there is a firewall that says public subsidized funding is intended for small struggling companies that can't otherwise get access to funding. And so part of, you know, the news is about certain public companies, but part of less prominent but pretty active lobbying in Washington is companies that are owned in part or whole by private equity and venture firms. And that firewall kept for those companies. The affiliation rule is also meant as a double check in terms of corporate responsibilities of the managers and directors of the company to understand, well, this may be a small enterprise that's the applicant, and yet we may have someone who's on the board of Amazon or Citibank or something, and we want to know about that before we provide subsidized taxpayer funds. So it's its own sub-branch of law specialty pretty active. And so the responsibility for the applicant is to know whether that applies or not.
Right.
And that's
I think
a
in Silicon
really
Valley,
technical thing. Yeah.
right up here in Silicon Valley, there was a significant concern with startups where they're owned through a VC firm, whether those startups could apply, given that they would have to aggregate, they don't even know who the VCs own, right? And they would have to potentially aggregate their employees with others.
Exactly.
Chris, do you want to address a franchise situation?
The franchise, right. So there's a carve out, right? I will, right? I think that the real issue for franchises is that, as I understand it, the CARES Act, and specifically the PPP, carved out the 500 employee. They said, as long as you have fewer than 500 employees, you can apply, unless you're a franchise, right, or some other that listed groups under the SBA codes, right? Then you're not subject to those 500 person rules. And of course, this is what's created the problems with Shake Shack and these other larger companies. But I think for our audience, for attorneys, I'm not sure that the affiliation, it's sort of an interesting question, but I don't think most law firms are not going to have an issue about whether they're affiliated or not, right? If your clients are, you got to be aware of this. Your clients are coming to you, ask you questions, but like a law firm, I think this is sort of it's not so important for law firms themselves.
Okay.
Yeah. So in terms of the 500, I said there were 4 things that I think are important, right? The first is that you got to be aware of those affiliation rules. The second is, well, when do you figure out, it says 500 employees, what is the computation date? How do you know when to test for 500 employees? The guidance says that you can use the average employment numbers over the last 12 months or in calendar year 2019, which seems like a sensible approach, right? Your employee numbers go up and down. The most important, and I think this is really relevant for law firms, is the treatment of independent contractors, right? When the guidance was initially, when we got the PPP, I think, I can't remember if the CARES Act itself defines this, but the guidance that came out pretty quickly after said independent contractors don't count for purposes of the 500 employee test. That is, it's got to be a W-2 employee to count to the 500. And the SBA guidance said, we don't want companies counting independent contractors because independent contractors can go out and get their own loans, right? And from a tax perspective, that makes sense, right? That we see contractors and W-2 wage earners as distinct, right? If you're a wage earner, you have withholding, everything else, but contractors get their 1099 miss and they pay self-employment tax and everything else, and they should be able to go out and get their own loans. In fact, guidance that was issued more recently made clear how contractors could go out and apply for their own loans. But what's important is that we didn't know how to treat partners in partnerships, right? And typically, partners in partnerships, like limited liability companies, that as many law firms are organized, are treated analogous to contractors, right? They pay self-employment tax, they get a K-1, not a 1099 miss, but they're seen as business owners, right? Running their own businesses. So I think initially there was some thought that if you had a limited liability partnership that you were running as a law firm, that partnership could go out and apply for its own loan, and then each of the partners individually, as a self-employed individual, could also go out and get a loan, right? For himself, like an independent contractor, right? And that within the framework of, within the tax framework of self-employed versus W-2 wage earner, that was coherent, right? But last week, or maybe 2 weeks now ago, the SBA issued guidance to say, no, you cannot, if you're a partner, you're not allowed to go out and get your own loan. Partners are for purposes of the 500 employee test, are collapsed into employees. And the SBA guidance says you've got to treat your partners as employees when calculating whether you qualify for the loan. And this is, at least from a tax perspective, this is entirely wrong. That is, right, it's not a coherent understanding of why contractors be treated one way, self-employed people are treated one way, and partners not treated a different way. But that's where we are. I don't know,
Chris,
if Linda or Paul, you guys have a, or maybe you.
Yeah, Chris, let me interrupt you 1 second. I have a question, but also, Paul, did you have a comment on that?
I have a couple little comments that I want to go back to. So the loan itself is a loan, and I've had this discussion with bankers. It's a loan because if your company is struggling to survive and it doesn't have enough oxygen to get to December, the owner has complete flexibility to have it as a loan for a year at 1% interest. If the owner wants to go to the other extreme and go for maximized forgiveness, awesome. There's a clear, semi-clear roadmap in how to do that. But the owners generally will go somewhere between those 2 points on the spectrum, number one. Number two, let us not forget, there is a plethora of disaster programs at the federal, state, and local levels. So people need to get up to speed on that. And as an example, from the SBA itself, there's what I refer to as SBA Classic, which is the Economic Injury Disaster Loan. That is very different terms. It is a real loan, and it is available. It ran out of funding last week as well. Last night's funding authorization replenished it with $50 billion. And then there is an actual grant program, which originally was going to grant $10,000 per person and now is $1,000 per person. Back on the affiliate rule, the number of employees is actually capped by industry by the SBA for like 50 years. And they update that every couple of years. So there's actually a specific exhibit because by industry, there might be a cap on revenue for the company and there might be a cap on headcount, which may be different than 500, just so you know. And then on the contractor point for attorneys here, your points are very well taken, but I have had discussion where there are independent contractors like the cleaning staff, which certain banks have allowed to be included because they are the equivalent of part-time employees. So the reason I mentioned that example is if you're an employment attorney on this call, the terms used by the SBA are not the terms that employment attorneys use. This is civilian speaking using rough indications of language. And so I just use that as an example of independent contractors are the same thing, but not in terms of the program or the bank.
So Chris, I have a question going back to something you mentioned that caught my attention because I think there are obviously a lot of attorneys on the call and some of them may have this situation. You mentioned that initially partners weren't included in the PPP definition of employee. And so many of them had to apply separately. So two questions come to mind. One, what if they already applied separately and got approved and suddenly the rules changed? And second question is, let's assume, and it's actually my situation, I'm technically not a partner. I have a professional corporation that's a partner in a partnership. So it employs me. I'm a W-2 employee, and that entity is a partner. Does that entity get collapsed into that employee definition, or is that separate? Right.
Well, those are both good questions, Uzi. I think the first hypothetical is an interesting one. Assume that the partnership went out and applied, and now it's gotten the funding, and now the partner thinks to himself, "Oh man," or herself, right? She says, "Oh man, I've applied for a loan too, and it doesn't count." My thought is that the guidance, and we were talking about this right before we got on the webinar, right? I think that the guidance is pretty good about saying, hey, you can rely on your understanding at the time you applied, right? And that in your hypothetical, I think that partner, she could probably say, hey, look, I made a mistake and I'm going to return this money to the bank, right? And that way I'll be compliant. But a more interesting question is, and I'll come back to your S corporation issue in a second, but assume this. Assume that the company had 400 employees and 150 partners, right? It's a large law firm, 400 W-2 earners and 150 partners. And it went out and applied in a conservative way for only 400 W-2 wage earners, right? It didn't count the partners. Now they get the money in and they realize, oh, partners are supposed to count. Can that law firm start to use the loans to pay partners as well as W-2 employees, right? For all 650 people, even though, it only had 400 wage earners, right? And Linda, I think you read the statute one way. I don't know. Do you want to, because I think as a technical matter, you could pay it out to everybody.
So Linda, what do you think?
Well, I actually think in that particular instance, you would rely on the guidance that was in place at the time you applied, right? Because I think there's a lot of commentary on that in the Q&A. But I don't think per se that, you have to pay dollar for dollar in terms of which employees you thought were being covered by the application. But I think at the core of it, you'd need to evaluate whether you, by paying 650 employees or whatever, you still really qualify for the program. I think in the end, if the partners applied separately and the partnership applied for only the 400 people, at some point there's going to have to be a reconciliation, and you can't, double count expenses, right? And so somehow it will be reconciled in the end.
That's a good point. There is actually an updated clarification recently that you can't double dip on the use of proceeds, and if you do double dip, there's definitely penalties.
Mm-hmm.
So here's another question. You're talking about what if you over-applied? What if you're a business, you're a law firm, and you initially looked at this and said partners don't count, and frankly, we're not going to apply for the partners. So you applied for 200 employees, and the loan is approved and funded. Suddenly, new direction comes out from the SBA, new guideline, and it says you can include partners. My understanding is that there's only one shot, one application. Can you correct it in any way?
Yes.
Can you add the partners now?
Yes. There's a risk, though. There's a price to that, which is, depending on the bank, generally, if you modify your documentation or your application, you go from wherever you were in the queue, and let's say you applied the first hour that the window was open, you go to the end. Most banks, when you do any changes, you go to the end of back to the end of the line. So you run the risk of being at the back of the line before the funding runs out again.
Well, Paul, but let's assume that you actually funded. So you applied for the loan, you funded, and now the partnership, now you recognize or you realize the rules have changed and you can include partners. Can you somehow go back and say to the bank, I didn't know? Or
they've been very clear from early on, you can make one application, period.
But I would think you would be able to use those costs as qualifying costs to get to your percentage calculation, and that would probably increase the likelihood of forgiveness.
Yeah, exactly.
Okay. So, Chris, what are the other qualifications besides the 500?
Well, so that's pretty much it. I think we had the 500 and the in place. I think the only other important factor that I think is relevant is that there are some carve-outs, and at least in California, one of the important carve-outs is the business can't be engaged in any activity that's illegal under federal, state, or local law. So consider the cannabis industry, right, which is a huge driver now in California, right? And there's always a tension between state law and federal law for those employers. I think only under the most liberal reading would cannabis companies be able to apply for loans. And there's also, and then Uzi, you've read about the bankruptcy standard. Do you want to talk? You yourself have talked about this.
Yeah. So this is an interesting issue for bankruptcy attorneys and for individuals and entities that are having problems and perhaps have filed or intend to file bankruptcy. If you look at the PPP application itself, it says you have first two questions. If you answer yes to either one of them, it says you will not be approved. And the first question says, is the applicant or any owner of the applicant presently, and usually it mostly says, violated the law, blah, blah, blah. And then it says involved in any bankruptcy. So the first question becomes, what if you have a company with an owner, maybe the 20% owner who happens to be in bankruptcy at that moment, but the company's doing well, the company actually has employees, is it possible that they won't qualify just because this language says that? Secondly, let's assume the company, the borrower, the entity, is in bankruptcy. It was pushed into bankruptcy because of the COVID-19 situation. Now we're telling them that they're not going to qualify for PPP simply because they filed bankruptcy rather than wait. It raises issues partly because if you look at the CARES Act itself, the legislation that Congress enacted, it doesn't say anything about bankruptcy. This appears to be an SBA invention. So I don't know if you guys saw this, but I can tell you in the bankruptcy community, it's been very controversial.
Yeah, at least from my reading of the initial guidance from the that the SBA published, right? Those bankruptcy is not one of the criteria listed as making you ineligible, right? It seems like this is an invention on the application itself. Although I don't know the history.
Do you think it might be a matter of trying to isolate then cause of uncertainty, whether the taxpayer was insolvent in advance of the COVID-19 crisis, and trying to, cause the applicant to determine really what is the cause of their need?
Right.
Well, but again, and Paul, I'll let you speak in a second, but it raises some problems because number one, if you read the application, and this is the actual SBA Form 2483. This is the form that the SBA created. This is not a particular bank. Basically, what they're saying is if you have an owner in bankruptcy, so it's not just the entity. If you have an owner in bankruptcy or the entity, and it doesn't leave room for we'll look at this and decide, Linda, whether or not you were viable or not viable, in February 15 or so. Basically, they're saying we won't approve your loan simply because an owner or the entity is in bankruptcy. And I think that may have discouraged a lot of people from applying. Or two, a lot of different entities, potential borrowers may have actually been turned down by banks. And I can tell you, an anecdote. I have a client who happens to be in bankruptcy, but his entity is thriving. The entity's doing fine, but he personally had some issues. And he called a large bank, I won't mention which one, and this is the bank he banks with, the business banks with, and they turned him down and said, look, you're in bankruptcy, you're out. I referred him to a small bank, and the bank said, no problem, you can apply. So it's not being applied evenly either. Just to mention that. Paul, what do you think?
I just, I'm not the expert on bankruptcy, so I just want to go back to the affiliate for a second. That's been around for like 50 plus years. There are two once in 50-year exceptions that have been made in the affiliate rules, which are quite significant, which is for the hospitality industry and the gaming industry, back as a parallel to what Christopher said about cannabis. Gaming is clearly forbidden under all SBA programs, period, not a penny, don't even want to talk about it. And yet, there was a clarification that said, if a company derives revenue from gaming, as long as it falls under $1 million in revenue in the examination period, and it's less than 50% of total revenues, it's fine, because of the next exception, which is glaring, which is in this legislation, there was a recognition that there was going to be, from a public health point of view, a dramatic issue with the hospitality industry, which is broadly defined, including bars, restaurants, hotels, etc. And so the affiliate rule essentially was put to sleep on the hospitality industry, and this sub element for the gaming industry was allowed because there's a lot of places that have, food and beverage that's, allows it to qualify. So there are unique exceptions there in terms of that.
Chris, do you want to talk a little bit about some of the other sort of small exceptions? For example, the idea of if you're a nonprofit entity, do you qualify? If you're a household employer, do you qualify? Anything else you want to mention?
Right. No, that's right. So nonprofits are able to obtain loans, although, just in the news, right, I saw that Harvard University had received quite a large loan and then decided to give it back. So it's not just these big franchises like Shake Shack and Ruth Chris that are coming under scrutiny, but Harvard itself, I think, recognized that although it qualified as a C3, it was politically dangerous to take the loan.
So Linda, my understanding is that the CLA doesn't qualify. Can you explain why?
I'm sorry, say that again.
Right.
I'm asking Linda why, for example, an entity like the CLA doesn't qualify, whereas a nonprofit under a different version of 501c3 does qualify. Why not CLA?
Right. Yeah. So in the statute itself, it clarifies that only 501c3 and C19 organizations qualify, which are charitable type organizations. Wasn't intuitive to me why that would be, and I'll let Paul confirm this, but it did refer back to the SBA rules and regulations, and inherent in that section of the rules was the concept that a business needed to be engaged for profit. And so it seems like SBA generally is not available for nonprofits, and that perhaps they've actually made a carve out for the PPP for charitable organizations. At least that's my interpretation.
Yeah, you're absolutely right about that. And then there's a whole subtext related to that, which is remember I just said it's not employment law. Well, in the employment law perspective, when we get into nonprofits, there were two updated rules issued to clarify the ability of funding to go to nonprofits that have a religious affiliation, and whether or not the employment by a non-for-profit that has a religious affiliation in fact has any conflict under employment law and freedom of religion. There's a whole subset of rules about that. And so the intent was to make it available for not-for-profits, but to not necessarily make taxpayer money available for nonprofit religious affiliated organizations that may have limitations on employment.
And Chris, you mentioned the cannabis, and I suspect you're right that if it's a strictly cannabis selling kind of business, your dispensary out on Main Avenue selling cannabis, you probably don't qualify because of the illegal aspect, federal law, illegality. But if you're a business that does tangential business with a cannabis entity, for example, you're selling growing lights, or you're selling a hydroponic equipment, what do you think?
Yeah, I mean, there's a huge body of law now that I'm not that familiar with, but I think, I think the general understanding now is that if you're tangentially related, it's okay, right, to be in the cannabis space, right? You don't violate the 280E rules under the Internal Revenue Code, but I think there's substantial risk for those sort of businesses.
I mean, practically, you're absolutely right. Practically, operationally, the lender of record is crediting the proceeds to a bank account. So if the participating lender is a federally chartered bank and they're taking funds from a federal program, it is unlikely to go to certain sectors of the cannabis industry because they're not legally permitted to have a bank account in a nationally chartered bank.
Okay. So, Linda or Chris, I wonder if we can kind of transition to the amounts of money one can expect to borrow and how one calculates the amount of the loan that you can apply for.
Yeah.
Sure.
Linda,
Chris,
do you
want to talk about that a little bit?
Sure. So it's a pretty, what seems to me as an accountant like a straightforward math equation, but essentially what you do is you take all of your qualifying costs for a calendar year, and that would be your payroll costs, group health insurance, retirement contributions, state unemployment and employment training tax costs. You calculate what the annualized cost would be. You divide that by 12 and multiply it by 2.5. That then provides to you what your maximum loan amount will be. As part of that process, you're going to provide to your bank copies of your Form 941, which is your quarterly payroll tax returns. If you're an independent contractor, you would be relying on your Schedule C documentation, possibly Form 1099 MISCs to support what your earnings generally are for a year. I'm not sure if I mentioned, but there is a haircut. You only count wages up to $100,000 per person. On top of that, you can add the additional insurance and retirement costs. So that's essentially how you come to what your total qualifying loan amount will be.
You can also include, you can also include, and this is an area where a lot of borrowers had to amend their application and slip down the line at the bank, which is state and local employer paid taxes are included to add to the application amount. Federal taxes are not permitted.
That's right. Yeah.
Right.
Mm-hmm.
And does anyone in the panel know whether the new tranche and the new legislation that's being deliberated on right now in Congress, is that going to change any of those requirements, or is it simply extending the original set of requirements?
To me, it looked like it was extending the original set. It just added more funding.
Yeah.
Okay.
The expectation is some of the anomalies may get wrinkled out going forward, but in the legislation so far, there's nothing different, as Linda said.
And so they haven't added any businesses that now will qualify. They haven't added anything different in that respect.
Not as yet.
Okay.
It was simply an amendment. It's just an amendment to Section 1102 of the CARES Act saying replace 349 billion with 659 billion. In all other respects, the legislation remains the same.
Okay. So either Chris or Linda, do you want to talk about, number one, what the loan would look like in terms of interest rate, in terms of timing? When do you have to pay it back? When do you have to start paying? All of that kind of information?
Yeah.
Linda.
So your covered period begins on the loan origination date or the date that you actually receive the funds. And that really does start the clock for an 8-week period of time. During that period of time, you're to expend the money for the intended purposes, right? Payroll, you're allowed to cover rent, utility costs, mortgage payments that are under, that were under some sort of a lease agreement or loan agreement prior to February 15th. And so you're going to start to capture all of your costs. And then when you get to the end of your 8-week period, right, you're going to measure what your actual costs were against what your loan amount was to start to determine, where you are in terms of utilization and possible forgiveness. I would also say that interest is going to accrue on that money at 1% during that period of time. Once you get to the end of your 8-week period, you will be in communication with your banker and start the process to request forgiveness.
So, Paul, do we know how the forgiveness process is going to go? Have you seen any guidelines that basically?
Excellent question. Excellent question. I've spoken to a number of banks already. They have absolutely no idea, but this is literally the one time in life where you have to ask for forgiveness. It does not happen automatically.
Does it have to be in a special chamber with the banker on the other side with a screen, or?
We don't know, and the reason I actually know about this and I'm being proactive is I don't want business owners that are concerned about getting back and starting in business to have to worry about the paperwork drama that they had in the last 3 weeks. And so I've gone to a number of banks and asked them, as soon as you have any idea of what you need, and Linda's laid out a very good description of the criteria, as long as you have good documentation to support eligible expenses that qualify during that period, you should be okay. The payroll companies have not been quite up to speed. Many of them have valid reports. Not everyone has them yet.
So
I guess I would like to add a little bit more to that. I'm actively advising my clients that we don't really want to be just relying on the payroll companies, right? Because the consequences here are pretty significant. So I think this is an instance where really you're going to want to maintain a duplicate or a second set of records, right? Whatever you normally keep for your accounting, but then I would strongly suggest everybody have a completely separate, PPP loan file where they not only keep their loan documents, but also every cost that, they're incurring that they are, thinking is a qualifying expense. And in addition to that, I'm also asking my clients to go through and sort of in a narrative format, articulate why it is they felt they qualified in the first place. Why that certification question that's in there about needing that the loan is certain current economic uncertainty makes the loan request necessary to support ongoing operations, right? I mean, that is such a vague threshold. And I do think that even though that might not be asked, certainly probably won't be asked, right, in 8 weeks' time when we go through a process of the forgiveness process, I have an expectation that somewhere down the line there will be review of some of these loans for compliance, and I think it would be an important step that you document in your file why you came to that conclusion in the first place when you certified.
So let me ask this, because I think it's important to distinguish between the pre-funding and post-funding. In other words, you fill out a very short, what is it, a 4-page, a 2-page?
It's really 2.
Whatever it is, loan application, which really doesn't ask for a lot of information. You send a few documents with it to show the payroll, but really, it's in the scheme of things, it depends on the bank, and it's really not much. At some point, I suspect there's going to be a reckoning. Once we're out of the situation, the government is going to say, we spent too much, there's a lot of fraud, we need to go back and re-examine some of these loans. What would you recommend for people to maintain in their records for the qualification part, not so much the post-funding, but to show that you actually qualified? What would you put, and you mentioned some of it, what would you put aside to show that you indeed were a qualified applicant?
Well, I think that that's going to be based on facts and circumstances, right, for every business. But whether that's that you were faced with furloughs and layoffs, whether all of a sudden your billable work dried up because of the client base that you serve, whether your receivables dried up because of your clients that you serve's lack of ability to make payments, your lack of ability to access other funding sources. So I think that for each applicant or each firm, business owner, sole proprietor, whatever that might be, there's a lot of factors that presumably we internally process, and I would just encourage everybody to take time to list all of that out, whatever that specific criteria might be, but then cause you to think, yeah, I need this money too because of this uncertainty.
The other thing I just add to that is, again, in the exceptional department, they literally published a rule that said, we, the SBA, understand you're having a problem working out the details and the documentation with you and the lender. We expect those problems, we understand it, but at the end of the day, it's the borrower's complete responsibility to make sure that they can document all evidence that supports the fact of their application and the amount of their application. And so I would say, to your point, Uzi, it's not just along the way, it's also go back to your work, check your work on that math test, make sure your work is valid. If you found a mistake, it's okay. You just need to correct it.
So,
and let me just, can I just add one point there?
Go, Chris. Go ahead.
Right. I'm at a law firm, right? And I'm a partner. And each day I see the receipts come in, right? And we have our costs. And again, in terms of satisfying what Linda says, I think is rightly a kind of very subjective criteria, this idea, what is economic uncertainty, right? I mean, the program really uses payroll as a proxy for what you should get, right? So my thought is, as owners of law firms, right, you figure out, I have a nut that I got to cover every month, right? And if you can show, look, we're not getting enough in the door to cover that, it seems to me like that's sort of prima facie evidence that you're not, that you qualify, right? That you've been adversely affected. That is, you are suffering economic insecurity, right?
So Chris, what I'm hearing you say is essentially maybe the bank statements are going to be some indicator of what money you had on hand at the time of the loan. But what if, and I'm guessing there's some people on this, call or program that we're talking about, who, let's say you work on contingency fee basis, and let's assume most of your money comes in when a case settles. And so you don't have a regular flow of money coming in. Every December, suddenly a lot of money comes in, or every 6 months you settle a big case or a medium case, and that's how you survive. How do you maintain the proper records to be able to say to the government, I really needed the money in April of 2020?
Right. Well, again, yeah, I think that's a great question, and I don't know that there's a good answer. But again, even if you have non-periodic income coming into the firm, you still have your fixed costs, like your W-2, you have all your staff, all your associates, everything else. Those costs don't ever go away, even if the income is not necessarily periodic. So my thought is, again, Linda did the best job saying it's a facts and circumstances test. But the bottom line is, what your rent is and your utilities and your employee costs. That you got to document. And if not enough money is coming in the door to cover those costs, I think you're prima facie okay on the PPP. That is the certification you got to make that you're adversely affected.
So here's another interesting fact scenario. At least recently, some of the large public companies have basically borrowed the money and had to return it, or basically decided not to do it because of the controversy. And there was some guideline that came out of the SBA that said, if you have access to markets, if you're a publicly traded company, you can go and sell more shares. Or if you have access to money through a lender, you shouldn't apply because you don't need it. What if you're a law firm and you have a line of credit that's not maximized? Are you required to first maximize your line of credit and then borrow the money, or can you borrow the money without maximizing the amount that you owe in the line of credit?
Line of credit is not, it's completely silent on credit and capital resources in that example for a private company. The exceptional example of publicly traded companies, SBA money has never been available for publicly traded companies. Never.
Right. And to be clear, that you're talking about, this is really important. I think we should spend some time on this. Yesterday, we just got a new set of FAQs from the SBA that seems intended to address this very issue, right? This concern that Shake Shack and Ruth Christ's and these other large companies are getting these loans, right? And that FAQ, and Paul, this is what you said, right? I mean, it's addressed specifically to large public companies. I don't think that if your law firm has a line of credit, or even your law firm, like Uzi, this for bankruptcy lawyers, this is, you guys are right on the threshold of like boom times, right? Does that mean that you shouldn't qualify? You know what I mean? Like, I don't think that FAQ 31 that we now have, which is supposed to be this kind of backstop, right? I don't think it applies to most of the firms.
So Chris, let me ask you one last question on this same, and Paul, maybe Linda as well. Let's assume you're a law firm, and in January, and you do PI, for example, or any other contingency type of work. In January of this year, a big case was settled, and a big chunk of money came in, and it's sitting in the bank account someplace. And suddenly we're hit with this whole coronavirus thing, and obviously no money's coming in. You really are not working much. The courts are not doing any trials, and everything is closed. You're still paying your employees, but you've got a chunk of money sitting in the bank because of January. You brought in some money. You apply for PPP. Are they going to look at this and say, but you had all this money, you don't need it?
I don't think so. I mean, I don't have a sort of rationale for why, but again, I think that arguably, just because you did great in January doesn't mean that you may not get another big case payout for 2 years, right? It seems to me that the PPP money is as long as you're less than 500 employees, right? You're in the bucket. That FAQ 31, again, very specifically, SBA worded it to deal just with public companies, not with smaller companies. So I don't know that just because you're flush, the firm is flush with money from a large settlement, a large case that it got, it needs to worry that it doesn't meet the certification requirements.
Yeah,
Okay.
there are, back to that size guide from the SBA, there are certain industries where they say if your revenues are greater than X, that disqualifies you under the affiliate rule.
Mm-hmm.
Most of those industries are silent on a revenue cap. And so there is no mention whatsoever about, in your great example, about any firm's revenue size unless it's in the SBA table, or cash in the bank. I would argue that from a public fiduciary perspective, the lender and the SBA would have a very stern discussion if that PI firm had $1 billion in the bank from that settlement. If they had a couple of $100,000 or $1 million or $2 million, everything I've seen is absolutely silent about the financial resources of the company. It's all about, at the margin, if you're going to be hurt from day one of this whole chapter going forward, and you have to consider as a result changes in staffing, it's available.
Okay. So just for Linda, go ahead. You have a point.
Just was going to say, I wonder though, if some of the criteria that's currently being measured, and this is just completely speculative, but in the employee retention credit, right, there is some measurable criteria there in terms of fully or partially suspended or a decline in gross receipts. And I wonder at some point if that may become a way that they measure this. I have a hard time getting my head around the idea that this would be intended to be a windfall for small business.
Right.
So generally speaking, if your business wouldn't have brought in money in the month of March and April or in May, because of the way you operate, your cases are such that you would have brought money later in the year. You're saying that maybe by taking the money, you may be putting yourself in a situation where at least there could be some questions.
Well, I don't know. I mean, if that was your normal, fact pattern, I mean, could you assert, in good faith that you were adversely affected, or is that just normal operations, right? I mean, again, I guess that's where it gets back to, I agree that the intention is to keep people employed, but at the same time, I think it's very important to look at your individual facts and circumstances.
All right, so let me summarize a few things and then maybe move on to the post, funding. But one, Linda, you mentioned it's a 1% loan. It's for 2 years. As I understand it, the interest starts accruing the day you get the money, but you don't have to start paying until 6 months after funding. Is that correct?
That's right. To the extent it's not forgiven at the end of the 8-week period, I don't think you do have a deferral period to start the payments.
Which is about 6 months. And then obviously at some point you can apply for forgiveness. So do we know what the process is? Do you have to apply, or do they automatically assume that everyone is going to ask for forgiveness?
No, that's what I said. That's what I said. I was being facetious but factual. You literally have to apply for forgiveness.
Okay.
If you want to take X $1,000 or $1 million as a loan and you choose to turn it into a 1-year loan at 1% interest, you're perfectly free to do that. And no one is holding a gun to your head to spend it in the first 8 weeks. If you lay people off and do that, there might be some discussions, but there's no reason you can't do that. But nobody will make an assumption it is not a 1-year loan at 1% unless you apply to your participating lender using their form and process and documentation.
So is there a form, is there a document that you can fill out now?
No, that's what I was saying.
Forgiveness?
No, that's what I was saying earlier. There is no form yet. I've talked to a number of banks. There's no form, there's no process. And I have my ear to the ground in terms of as and when they make those choices, they'll start letting people know.
So anything else people should know about in terms of applying for or qualifying for the loan before we go to the post-funding?
Well, maybe what might be, Uzi, I think something, given that I've published a lot about independent contractors and partners, I think something that's important, and I don't have an answer, maybe Paul knows, that I think like a lot of sole proprietors, like let's say you're an attorney and you're just a sole practitioner, you got your own shop, right? And you get paid and, you know, you file, it's just on your Schedule C, right? And I think a lot of those people have had significant difficulty getting PPP loans because the banks won't let them apply, right? That the bank said, only if you have a business account will we let you apply, right? So imagine some younger attorney who's just starting out, right? And he works as a contractor. He's got his own self, right? He's just got his shingle out, right? I think the banks have created this artificial barrier for a lot of people who maybe the loan should have been intended to go to them, right? And because they don't have the necessary banking relationship, it's been hard for them. I understand that some of these people have had success going through online banks, but I don't know, Paul, maybe you have some thoughts on this?
I know a lot of people like that who have applied to banks, some of whom have already gotten funding in the first round, some of whom are head of the line in the second round. One of the handicaps was if you fell into the sole proprietor independent contractor status, you couldn't apply until the 10th, when the money was basically gone by then. So that's why they're sort of hopefully first in the second funding.
Yeah, but my point is that the bank would say, hey, unless you have a business account with us, we're not even going to let you apply.
Right. I mean, I've seen many attorneys that are sole practitioners that have applied and are in the queue or got funding from commercial banks, not from online fintech places.
Right.
And Chris, let me give you a little bit of my insight. I think you're right that some of the banks, number one, had issues getting up, ramping up to this. So just put that aside for a second, but not all banks are equal in terms of how quickly they could respond to this whole program. Some of those banks did, it seemed, favor clients with long-standing accounts. If you have that situation, your bank doesn't think that you've been there long enough, or if you don't have an account there are some smaller banks, and that was my experience, that are willing to take you on and fund your SBA loan, the PPP, without having an account there. And that was my experience. But you probably have to call around, and I wouldn't just rely on one or two banks. Mm-hmm. Talk to people that you know who have used the program. You can reach out to me, and I'll tell you where I went. I'm not going to say publicly, but there are some smaller banks that are trying to make names for themselves, or for whatever reason are not requiring a pre-existing account. And don't sit on it too long. I would call as quickly as possible. Talk to as many people as possible. Not always easy to get calls back from bankers. They're very busy. They're working from home, and so many of them may take a day or two to return to you to call you back. But you do have to do some legwork and some homework in order to get the right bank.
And that's true. I think another sort of filter for those kinds of banks there are a fair number of banks that like and understand professional services, accounting, law, medicine, whatever it may be. So they get that. And maybe that's sort of what I've experienced in the examples I was referring to. There's even some very big banks that like law firms and like law practitioners, but you need to get that department, not the branch.
Right. So, by the way, I see a question. Someone was asking whether we can post the FAQs that we keep mentioning. Is there anyone on the panel who has the ability to quickly post, or maybe we'll do it later?
Yep.
Just post it on the chat room so people can click on it. But the other thing I would say is if you go to Google and just put PPP and SBA, you'll probably find it fairly easily. But if we can put the link, that would certainly be appreciated.
Okay.
In terms of, I see another question. The second round, the second tranche coming up with about $300 million or so. Any sense of how quickly that money will be used up?
The experts that I've read indicate there's about $1 trillion of demand for the 350 that was voted on last night. So it's going to run out quickly.
Okay. So obviously the advice to everyone here is apply as quickly as possible. And what happens if you applied for the first tranche and you didn't get it and your application is in? I assume it's automatically going to be considered for the next tranche?
In the squeaky wheel gets the grease department. I've asked everybody I talk to, and I'll include this group, that you should be reaching out to your bank where you applied, and you want to find out whether the status of your application is documentation is valid and complete and either has been or ready to be submitted to the SBA. If it is not yet complete, you want to know that as soon as possible and fix whatever technical thing is missing.
So here's a question in terms of practicality. Let's assume you call your banker and the banker says, listen, everything we need is in. Your application is complete. We'll get back to you. And it's taken days. When would you say to your client, enough is enough, go find another bank because this bank is just not going to come through?
I've had that use case countless times in the last 10 days. And I've said, in my judgment, talking to the banks, to the extent that you are a new applicant at a bank and you already have an application, theoretically, you could risk losing both applications because you're only supposed to apply once, theoretically. The system's pretty big. They did $1.7 million loans processed in 14 days, which is an incredible record. But I would say nag the first bank, and I will tell you with certainty, you will not get an answer easily. You will not get an answer immediately. They literally don't know whoever the contact person is for you. Keep asking. And just set a time deadline where you say, if I don't know, today's Friday, if I don't know by Tuesday or Wednesday, I will identify before Tuesday or Wednesday what bank I'm going to and have a discussion with them so I can lodge an application.
All right, so we've got 10 minutes to go, and I want to make sure we cover the second part, which is you've now qualified, you funded, and my understanding, at least in my experience, is you should get the money within 10 days or so when you hear that you qualified, to give or take. You're going to get a promissory note of some sort from the bank saying, here's everything you agreed to. You'll certify once again that your firstborn is going to be returned, given back to the bank if you didn't give the right information. It talks about what happens if you change ownership in your business. It's possibly a breach and things like that, but you'll see that in the promissory note. But now you qualify. Linda, what would you tell a client, now that they have the money, that they need to do to be in the best position to get that forgiveness?
Yeah, so this is really going to be a situation where documentation is just critical, right? Some banks are suggesting that you have a separate bank account and the PPP proceeds go into that account. I don't think that's necessarily a requirement, but that would certainly be, one way to track your spending. But again, I would just encourage everybody to keep really solid records of all of the disbursements, whether it's payroll, rent, utility costs. I know a lot of small business in particular, but even if you're with a larger firm, your accounting department should have the wherewithal to create perhaps like a department code within your accounting system, or if you're using QuickBooks, that might be a class. I think it would be a real good idea for all of the disbursements to be coded in some fashion that, again, down the road, if you're, called to provide more support in the future, you would have a good mechanism in place and solid records. You are going to have to provide the same type of records that you use to get the loan approved. You're going to have to provide similar support when you ask for forgiveness on the loan proceeds. So again, that's going to be your quarterly payroll tax returns, your calculation in terms of full-time equivalents, how you're demonstrating that number didn't go down. Probably want to keep copies of your lease documents that support that you had, in fact, a valid lease on February 15th. Documentation.
On the
Is
bank
there-
account, is actually quite important. Please do not open a separate bank account until after you've confirmed with your payroll company whether it makes sense or it's going to make things worse. That's really important. Some payroll companies, it's easy. Some payroll companies, it's going to make things very painful.
Is there different advice for a law firm that's maybe a single practitioner or maybe just a few employees where they don't always follow the regular payroll requirements? They may just take a draw and then ultimately at the end of the year just square it up. Any kind of advice for a smaller operation that may in the past not have had an ADP account, or they may just make it a very informal type of payroll?
You're at risk. I mean, I think the answer is you got to be careful, right? This is, you're dealing with the federal government now, right? Where you sign under penalty of perjury that you'll do X, Y, and Z. I think, it's everyone's welcome to take their own business risk and have their own risk profile, but I think it's pretty dangerous to not keep the records that Linda has described.
Yeah.
So basically,
Did a good
there's
job
no
describing it.
difference. You're saying if it's a small shop, a one-person shop versus a 200 person shop, keep all the records the same way.
Absolutely.
The only caveat I would say, Linda gave an excellent example of it, is to the extent you choose to do something different, there's a whole complex, and Linda knows as well, there's a whole complex area of employment tax and certain benefits and programs where you may make certain types of payments to employees / partners that you didn't pay before. And so you definitely want to, as Linda said, make sure you talk to your payroll company, and to the extent that you're doing something like a FFCRA tax credit, or you're doing emergency sick leave, which is different and theoretically not qualified spending, as opposed to paid leave like sick leave and family leave. You want to make sure that's labeled correctly.
Okay. I'm trying to think. Anything else that maybe we didn't cover? Any topics, Chris, Linda, or Paul, that you think would be important for people to know?
From a cash flow perspective, I alluded to this earlier. Money is money is money. In the beginning of this program, they said there's 5 flavors of expenses that we will allow for the use of proceeds, unchanged today. But because of the urgency and the complexity of counting those 5 flavors, they said, you know what? We're only going to compute the amount you can apply for using payroll. And so it's really up to whoever's running the organization to make a judgment about, if I pay everybody and be a great human being, can my business survive until month 3? Because based on payroll, it only lasts 2.5 months. And if you have issues around your confidence, because nobody can predict what's going to happen, but we need to do some contingency planning, you need to really sharpen your pencil or get somebody qualified like Linda, to help you figure out how does your firm stay solvent and above water so that at month 3, the people you can afford to keep on your staff, you're able to be in business to hire them.
Okay. Linda or Chris, any final words as we kind of wind down?
Well, yeah, my point would merely be, and we discussed this a little earlier, right? So the SBA issued that recent FAQ with the new FAQ 31 that says, look, if you're a big public company, you shouldn't go out and get the loan. But I think my gut reaction is that the SBA is going to start policing this more, right? That they're going to realize there's political risk here for the government to be giving these handouts. And so I guess my advice to people would be, don't just treat this as free money, right? That you really do have to document it, as Linda said, or as Paul said. I mean, this is a big responsibility, and it's like a tax return. You're signing under penalty of perjury that you'll use the money this way, right? And so it's not just free money. That's my thought.
Okay, Linda, any final parting thoughts?
No, yeah, I agree with what Chris said. I think there's a lot of really interesting articles being written on, how this is maybe going to play out in the coming weeks, and there's a lot of food for thought out there.
So, Ona, before you make your final closing as well, I want to point to everyone that if you look at the chat portion of your screen, Paul put a link to the FAQs from the SBA. Someone had asked about those. So if you want to read those, I think they're really helpful. And again, they're on the right side of your screen. If you click on chat at the bottom, there should be a portion of your screen that becomes just a white portion with chat comments, and it's in there. Otherwise, I want to say thank you to all the panelists, and thank you for inviting me to be the moderator. I really enjoyed it. I think we got into some really good topics, and I would urge anyone on this call who's been on this program, if you have any questions, to reach out to anyone on the panel, and I'm sure we'd be happy to either answer the questions or refer you to the right person who can do that. Ona, all yours.
Thank you so much, Uzi, and Paul, Linda, Chris, thank you very much. I think this was excellent. For those folks who are members of the audience, so to speak, who know other people that might be interested in this content, we're going to get it posted, excuse me, posted on our website that is calawyers.org over the course of the next few days. We'll also put a link to the FAQs. That's easy. We should probably have that up by the end of today. Again, I really want to thank you, Uzi. You did an extraordinary job moderating. Paul, Linda, Chris, thank you so much for your time. It means a great deal that you would share your expertise with lawyers here in California, especially since I know that you are all busy in the trenches with this program. So thank you very much on behalf of the California Lawyers Association. Deeply appreciate it. Have a great rest of the afternoon, everyone.